I think when we talk to the public about it, it's going to scare them.
The government agrees to take care of the public safety.
Defendants have a right to a speedy trial.
And it's constitutionally guaranteed. Where is it?
Lowering the caseload standards is absolutely a necessary step. It's going to be painful.
Public defenders around the state of Washington, they're giving up their lives for this state right now.
I think your worst case scenario is that people start to feel frustrated and feel like that there is no justice for them and they take it into their own hands.
That has crisis written all over it for every county in Washington.
If you're charged with a crime, you have the right to an attorney. And if you can't afford a lawyer, the government is required to provide one for you. The majority of people facing criminal charges fall into that category.
Between like 80 and 95% of felony cases, folks are indigent, meaning they don't have enough money to afford an attorney.
But what if there's no one to call?
This is a huge crisis.
In counties across Washington, there are not enough public defenders to keep up with the criminal cases being filed. For the accused, it could mean extended time in custody before their day in court. For the victims, it could mean watching the case delayed or even dropped because the system is overloaded.
If we can't get an attorney assigned and they cannot get a trial within that time period that's set out in statute, they may have to be released from jail and their case may have to get dismissed. And that doesn't matter whether they're a violent offender or not.
Kristen Bishop is a public defender in the juvenile division in Mason County. The local public defender's office has been scrambling to find private attorneys for every adult defendant facing a felony charge because there's no one on staff to handle those cases.
Currently, we do not have a chief public defender, and we're also down 2 attorneys and our only paralegal. So our office has been crippled by the loss of those positions. We really can't function the way things are. It's also causing defendants to have to sit in jail longer than is necessary because it takes some time for us to find outside attorneys to represent them. It's absolutely not sustainable for us to continue to go without a chief public defender and without felony attorneys.
From his office in Shelton, Mason County Superior Court Judge Monty Cobb says the county has struggled to hire prosecutors as well as public defenders in the past.
I mean, it's like your car. If you take out a part of your car that's a necessary part, it just doesn't work. And you may be able to get down the road, but it's not fun. Or it's hard, or it doesn't run well. And that's where we kind of are. We've been very fortunate that the private bar in the area has stepped up to help us out, and that's really kept us afloat.
The private attorneys filling in as public defenders in Mason County are coming from other parts of Western Washington. In Eastern Washington, the shortage is more pronounced. The backlog of cases and scarcity of public defenders has been so severe in some areas that the wheels of justice ground to a halt.
We heard one nightmare scenario case in Central Washington where someone who was arrested for a violent rape was actually let go because they could not find a public defender in time.
Derek Young leads the Washington State Association of Counties. He's referring to a situation in Benton County where several defendants were released in mid-2024 when the county couldn't provide them public defenders quickly enough to avoid violating their right to a speedy trial. The situation also reached a boiling point in Yakima County, where the local justice infrastructure has been battling a backlog of defendants with no public defender to represent them.
Do you know how to confirm hearings? Tell the clerks you need to confirm the hearings.
The ACLU of Washington filed a class action lawsuit alleging that low-income defendants have routinely been held for weeks in jail, waiting for a public defender to be available, and that those out of custody have been forced to return to court repeatedly for months with no way to advance their cases. In general, criminal trials in Washington must begin within 60 days of arraignment for defendants who are being held in custody and within 90 days for defendants who are not being held based on procedural rules. There are situations that can extend the timeline, but missing that deadline without an approved delay can lead to a charge being dismissed with prejudice, meaning it can't be refiled in the future.
There were cases in one of our counties where a judge decided to take it upon themselves to basically press attorneys sitting in their courtroom into action to at least get arraignments. You know, imagine you're there for a real estate transaction or something along those lines, and you're being drafted into taking over responsibility for a criminal defense. That's what's going on right now.
I manage the western side of the state for recruitment and retention.
Nat Jacob with the Washington State Office of Public Defense is helping to pilot a new rural public defense fellowship to help smaller counties fill gaps in their public defense workforce.
There's certainly a divide among law students about where folks want to go after law school.
He says law school graduates entering the workforce tend to gravitate toward jobs in urban areas after passing the bar. At a private law firm,
they might be getting paid an awful lot more than they would for public service, but what I've found is that there's a contingent of law students, and it seems to be growing by the year, that are really interested in and focused on wanting to be in public service and specifically public defense. Whether or not that is going to be something that ultimately sticks as the kind of financial realities become more and more evident for them remains to be seen.
The findings from a statewide public defender job satisfaction survey were published by the Office of Public Defense in 2024. The survey found public defenders start out highly motivated and enter the job with a sense of mission. But over time, the toll on their personal lives, the high caseloads, low appreciation of their efforts, and higher pay in other career tracks drive many away from the profession.
It's hard to do the work that we do. We have very challenging work. We deal with people on some of their worst days.
At the city level, there are municipal courts that handle code violations, traffic cases, and some misdemeanors that occur within city limits. Cities provide the bulk of the funding for those. There are two types of courts at the county level. Gross misdemeanors and misdemeanors go to district court, and the most serious cases go to superior court. That's where the felony trials are held. Superior court and district court operations are funded mainly by county, not state dollars. The Association of Counties challenged the legality of the public defense funding framework in a lawsuit against the state.
More than 2/3 of states pay for at least half of the cost. We are an extreme outlier.
Since 1980, for 45 years, the issue has been out there that this is an unfunded, a not appropriately funded indigent criminal defense system. The state legislature each year refuses to do more.
Defending the state, the Attorney General's office countered that Washington law has always given counties the primary responsibility for funding trial court operations. The AG's office also argued that counties shouldn't be allowed to sue on behalf of the indigent defendants that the counties themselves are prosecuting. In court filings, the AG's office calls that a clear conflict of interest.
There is no claim, like anywhere in counties, that they are representing the interests of indigent defendants. They're representing their own budgetary and financial interests.
State lawmakers recently approved an increase in funding for indigent defense, which doubled the grant capacity of the State Office of Public Defense. Young says it's a drop in the bucket compared to the actual costs. He contends the funding framework is unsustainable.
Now we face a situation where the Supreme Court has weighed in again and decided to now triple the costs of public defense.
In 2025, the Washington Supreme Court ordered a 2/3 reduction in the maximum caseloads for public defenders to be phased in over 10 years. Under the old framework, formalized in 2012, a public defender could carry up to 150 felony cases per year, or 400 misdemeanor cases. Caseloads will eventually max out at 47 felony cases per year, or 120 misdemeanors. Some jurisdictions that weight cases based on complexity may set the limit much lower. The Supreme Court left case weighting optional for cities and counties. The court's order instructed cities and counties to transition as soon as reasonably possible. and characterized the reductions as a necessary change to provide effective legal representation, with Chief Justice Deborah Stevens writing, quote, "The crisis in the provision of indigent criminal defense services throughout our state requires action now."
I think it's a giant step for the state of Washington and for public defenders moving forward.
Larry Jefferson leads the State Office of Public Defense, which has been a key advocate for the caseload reductions. Jefferson says excessive caseloads are one reason turnover has been such a problem in the field, but not the only reason.
Public defense across the entire nation has been underfunded. And in particular, in the state of Washington, public defense has been underfunded ever since I've gotten into public defense. We've also had a turnover of just attorneys in general.
The caseload cuts stem from new guidelines from the Washington State Bar Association, which followed a 2023 study involving the Rand Corporation, the American Bar Association, and other stakeholders that concluded widely used caseload standards don't leave public defenders enough time to work each case.
Stop! Stop! Get on the ground now!
Advocates of lower defense caseloads contend recent years have brought an explosion of potential digital evidence from body cameras and smartphones. They stress that rushed and overwhelmed public defenders can't give clients or cases the attention they deserve and are more likely to result in problematic plea deals.
I think what keeps us up at night is the workload can be absolutely overwhelming. And the fear is, did I miss something? Did I miss something that could have helped my client, that would have benefited my client, that without having seen that, their case is going to go a different way.
Washington's public defense structure is decentralized. Counties and cities run their own public defense operations, and the models vary widely. Some jurisdictions have full-time public defenders on staff. Many hire private attorneys through contracts or assignment lists. In sparsely populated areas, there may be very few available lawyers.
Some of our counties, they would actually have to employ every member of the bar in that county as a public defender in order to cover their caseload standards. That's how serious this situation is. So there simply aren't enough attorneys to meet that standard.
The Association of Washington Cities also strongly objected to the caseload reductions.
If these new standards are adopted and counties are forced to reduce by 70% the caseloads for their public defenders, we can be sure that one of the ways that they will handle this is by charging fewer cases as felonies. The impact of this will be yet another increase in misdemeanors, adding further strain to cities.
In a letter opposing the caseload restrictions, the Washington Association of Sheriffs and Police Chiefs predicted the implementation of the proposed rule will result in a systemic lack of accountability, adding, "Justice is not solely a process for the accused."
In places like Yakima, you heard some of the statistics. There are way too many individuals who are sitting in court and way too many individuals who've had their cases either dismissed or not filed because there are not enough public defenders.
Washington Association of Prosecuting Attorneys Director Russell Brown worries that jurisdictions won't be able to boost staffing enough to comply and will be forced to let crimes go unpunished.
If you needed 10 right now and all of a sudden now you need 30 and you don't even have your 10, I think that just creates a real challenge. The government agrees to take care of the public safety as their primary duty to make sure that the communities feel safe. And if the criminal justice system can't do that, I think your worst case scenario is that people start to feel frustrated and feel like there is no justice for them and they take it into their own hands. I think what you're seeing is in many communities there's a growing sense that the criminal justice system isn't taking care of this agreement.
Mason County Prosecuting Attorney Michael Dorsey notes that rural areas like his with a smaller tax base are often in competition with areas that have more money to attract new hires.
We're surrounded by Thurston County and Kitsap County and to an extent Lewis County and Grace Harbor County, Pierce County kind of, and they just frankly can and do pay a lot more than Mason County can. So it's been real difficult on both sides to compete for what is a limited resource out there, which is available attorneys to do the work. It's an immense pressure on the system, that, not just the public defenders, but on the prosecutors, on the court judges and court staff. And frankly, it's a stress on the community. It's not hard to see that results in prosecutable cases that maybe aren't getting prosecuted because we're having to be choosier about the ones that we can go forward on. And we're not really to that point yet, but that's where it's headed.
It doesn't mean that prosecutors won't file charges. In most cases, they still will, but they won't be able to find enough public defenders to actually go through the system. That may mean more plea arrangements that shouldn't have been entered, but they're desperate to move a case through the system quicker. But in many cases, people are going to go free.
The ACLU of Washington supports the caseload reductions, and in written comments to the Supreme Court said the RAND study tells us in no uncertain terms that every public defense system in our state is below the minimum standard necessary to protect the rights of people charged with crimes. The ACLU later adds, the public defender shortage will not improve until we can stop the exodus of attorneys from public defense. The only way to do that is to adopt new, manageable standards. As justice system stakeholders try to envision a future with 2/3 more public defenders on the payroll or 2/3 fewer cases, a December 2025 meeting of the Washington Senate Law and Justice Committee revealed just how much uncertainty remains about what it will take to pull off a paradigm shift for public defense.
Do we have a sense of if the state covered all the costs of the new caseload standard, how much would we be paying?
No.
We have no sense of that?
No. And here's
so we're asking local governments to cover it, but we don't have a sense of the cost.
We don't have anyone responsible in the state of Washington for telling you what those costs are. And we don't even know how many cases there are, how many public defenders there are. We don't know. So that's a big challenge then to ask you to figure out how much it's going to cost statewide. Whose job is it to gather all of that and tell you that? There's nobody whose job that is in Washington. There's nobody who's done that.
Larry Jefferson agrees that courts are underfunded and staffing increases will be challenging, but says his responsibility is supporting public defenders to protect the rights of the accused, whose freedom may be on the line, because an arrest can have life-changing consequences well before a trial.
If you're held, you might lose your job. You might lose your apartment. You might lose your house.
As for the concerns about caseload reductions leaving less room for new charges,
I think we need to take a look at what cases we're charging, whether we're doing it from a victim-centered approach, meaning do victims want this to go forward, or do they want other alternatives? And there's certain things we can do. Right now we charge a lot of driving while license suspended cases. We could decriminalize those. We have options that we could use.
There have been a lot of things we've done over the past few years that have been good. Increased diversion, increased treatment, increased reentry. All of those things are important. But simply to say we are going to act in a way that limits the number of people to go through the criminal justice system as a metric to a win, I think is short-sighted. Again, assuming everything else stays the same. In my mind, that means assuming people continue to commit crime.
I think there's a misconception about public defenders. And I want people to know that public defenders care not just about getting our client off of this particular charge. We care about our communities. We want safe communities. And we feel that one of the best ways to have safe communities is for folks that have been charged with a crime to have a public defender who has the time to sit down and talk with them and find out what's going on in their life. Why are they in this situation? What led up to it? What do they need to help them so that they're not going to be in that situation again? Lowering the caseload standards is absolutely a necessary step. It's going to be painful.
Well, I think everybody cares about criminal justice. I mean, you watch the news at any time, the lead stories almost always are criminal justice or bad weather. The standards adopted by the Supreme Court with the 10-year kind of implementation, still going to be problematic. It's workable. There are lots of moving pieces in this organism, and I think we're throwing it out of balance. There's a good reason to make some changes, but I think we're going to find balance problems again.
But ultimately, we can finger point, we can say who's to blame here. The reality is it is failing, and it doesn't really matter. The public expects us to solve this problem.